Hi, my name is Ben. I am a law student, and today I'm going to be talking to you about offer and acceptance, which is the first topic that most contracts classes cover in law school. Before I start, I have a quick disclaimer for you because I am in law school. So of course, this video is for educational purposes only. It's not legal advice. If you need legal advice, get a lawyer. Also, the information in this video is accurate to the best of my knowledge, but viewers assume any risks resulting from errors made by the creator of this video. That's me. So with that said, let me get into what I'm going to be talking about today. I'm going into my second year of law school. In my first year, I took contracts, as I think everyone does in their first year of law school, and I created this flowchart as well as a number of other flowcharts, which I found to be a very helpful way of understanding the subject matter, and I distributed this flowchart and others to my classmates. People told me the flowcharts were helpful, so I thought maybe I would make some videos and share my work with a larger audience. So hopefully this will be helpful to you. This is not every single piece of information you could know about the topic, but it should be enough to get you through a first year contracts course in law school, or if you're just interested in the topic and you're not in law school, this will give you some information about what you would be learning if you were to go to law school. So with that said, I want to get into it, but before I do, just a few basic things since this is my first contracts video. What is a contract anyway? Well, a contract is a legally enforceable promise. That's how you should think of a contract. People make promises all the time. Not all promises are legally enforceable. Once they become legally enforceable, they are contracts, and we're going to talk about all the different things that go into making a promise legally enforceable. Okay? And where does contract law come from? Well, there's two main places it comes from. There's the UCC, which is the Uniform Commercial Code, and that governs contracts for movable goods. There's also the state common law, which governs contracts for pretty much everything else. These have a lot of things in common, but there are some differences, and when there are rules that are different between the UCC and the common law, I will try to point out where those differences are. If I don't say anything, assume I'm talking about the common law is mostly what I'll be talking about, but sometimes I'll talk about the UCC as well. Okay, so our first topic, offer and acceptance. Now, to make an offer and have an acceptance, we need two parties, the offeror and the offeree. These are terms you're going to need to know to follow a contracts course. Pretty simple. The offeror is simply the person making the offer. The offeree is the person who is receiving the offer. So with that said, let's get into the actual flowchart. I'm going to spend the rest of the video breaking down this flowchart. And if I just kept the same image, that would be pretty boring. So I'm going to build the flowchart piece by piece, starting with offer. So what is an offer? Well, an offer is words, actions, and conduct manifesting an intent to enter a contract according to a reasonable person. And that definition is known as the objective theory of contract. Also note that the letter K is how contract is often abbreviated, typically abbreviated in the world of law. So, objective theory. Now, what would be a non-objective theory? Well, there was a time in law when to have a contract, this was understood as requiring a meeting of the minds. Both parties have to look at the contract the same way. That's no longer the case. So the objective theory means that your intentions don't matter. What matters is what you say, how you act, your conduct, and how that would be interpreted by a reasonable person. So if you say, I will pay you $20 to rake my leaves, but in your head you're thinking, this is not a real offer, I'm making a joke. Those thoughts in your head do not matter. The only thing that matters is what you are externally manifesting to the other party, and that is known as the objective theory of contracts. That's what we need to have an offer. Words, actions, and conduct that a reasonable person would take as an offer. We should also note that an offer is going to need to entail sufficient clarity of terms that we would be able to know if the terms had been breached. So you'd have to say a little more than, I offer you money in exchange for work. Well, how much money and what work? We're going to need to have at least that much clarity in order to have an offer. What might we have if we don't have an offer? Well, we might have an advertisement. An offer and an advertisement are not the same thing. Usually a reasonable person is able to tell the difference. An advertisement is a mere solicitation, not an offer. It requires a further manifestation of assent in order to get to the point of being an offer. Why? Because of something called the multiple acceptance problem. So if you see an ad on television that says, come into McDonald's and get 2 cheeseburgers for $1, and you run over to McDonald's and you say, here's $1, give me my 2 cheeseburgers, and they say no, have they breached a contract with you? They have not, because a reasonable person would understand everyone cannot accept that solicitation, the thing in that advertisement, because eventually they'll run out of cheeseburgers. That's called the multiple acceptance problem. So an advertisement, you should understand, is not an offer from a legal standpoint. Because of this multiple acceptance problem, it's soliciting you to make an offer. The advertisement itself is not an offer. So we're going to go forward with offers in mind, not advertisements. There's 2 kinds of offers. Bilateral contract offers are the first kind we're going to talk about. There's also unilateral offers. We're going to cover both. We're going to start with bilateral contract offers. This is the most common kind, the default kind. Bilateral simply means it's an offer that would be accepted through a return promise, right? So if I say, I offer you $20 to rake my leaves, and you say, I accept, I will rake your leaves for $20. That is an acceptance through a return promise. That's a bilateral contract offer. Now, once the offer is made, I will pay you $20 to rake my leaves. The power of acceptance passes to the offeree, and the offeree has a number of things they can do, and we'll talk about each of those. But first, I want to talk about that power of acceptance might terminate under certain circumstances before the offeree has a chance to accept. So what might make the offer terminate? How might the offeror terminate the power of acceptance of the offeree? Well, that power of acceptance, that offer could terminate through revocation. The offeror could simply say, I take back this offer. It's no longer on the table. Now, revocation is valid upon receipt. So when the offeree receives this notice that the offer has been revoked, it's revoked at that time. It could also be revoked in an implied way via information from a reliable source. So say the offer was to sell a car, and the offeree walks by the car and sees a big sold sign in the window. Well, that's going to be a pretty good indication that the offeror has taken some kind of definite action that's inconsistent with an intent to sell the car. So that's going to count as a revocation of this offer. Okay, so that terminates the power of acceptance. There's no power of acceptance if it's an illegal offer. The power of acceptance can lapse. When does it lapse? After a reasonable time, which is going to depend on the circumstances. It could be when the conversation's over, it could be longer than that, or a specified time. I will keep the offer open for a week or a month. Now note though, even if there is a specified time, the offeror is able to revoke the offer before that specified time is up, unless the offeree has provided consideration to keep the offer open. Consideration means something of value, usually money. So if I'm the offeror and I say, I'll sell you my car for $1,000, and the offeree says, well, I need to think about it. I want a week to think about it. I say, okay. Well, am I bound to keep this offer open for a week? Can I turn around and sell the car to somebody else the next day? Sure, I can. unless the offeree has paid me money or given me something of value to keep the offer open, I'm not bound by that time. I can still do what I want, unless they've given me something of value, some kind of consideration to keep the offer open. Okay. What else? Death of offeror terminates the offer. Rejection of the offer terminates the offer. And a counteroffer also terminates the offer, terminates the power of acceptance, right? The power of acceptance of the original offer. So we'll talk about this more when we talk about acceptance. But if I say, I'll give you $20 to rake my leaves, and you say, I'll do it for $25, now that's a counteroffer. If I reject that counteroffer, can you turn around and say, all right, I'll take the 20? Well, that would be making me a new offer. Maybe I'm insulted that you're asking for $25 and I don't want to do business anymore. Well, if I say, rake my leaves for $20, I'm making you this offer. You say, I'll do it for 25. I can walk away. As I'm walking away, if you say, no, I'll take the original 20, well, you don't have the power to accept that anymore. Now, if I still want to have that dealing with you, I could, but when you make a counter offer, you terminate your power to accept the original offer. It's up to the person who made the original offer whether they still want to extend that offer to you at that point. Okay, so those are ways that the power of acceptance can terminate. Oh, and counteroffers. If performance begins, the last counteroffer is going to become the terms of the contract. That's what's known as the last shot doctrine. And this is something that only applies under the common law. It does not apply under the Uniform Commercial Code. It does not apply to movable goods, only services, things governed by the common law. But if performance begins, the terms of the last counteroffer become the terms of the contract. Okay, so that's when the power of acceptance can terminate. If that doesn't happen, the offeree can accept. Now, acceptance under common law is going to mean acceptance of the exact terms of the contract. This is what's known as the mirror image rule. If the offeree changes anything in their acceptance, it's not an acceptance anymore. It becomes a counteroffer. The acceptance has to be the exact terms of the original offer. That's what has to be accepted. Anything else is a counteroffer. Now, again, this is different under the UCC. It's different for movable goods. We would need another video, which I'll plan to make later, about how this functions under the UCC. It's quite different, but for common law, the acceptance has to be for the exact terms, the mirror image rule. Now, this acceptance is valid upon dispatch. That's known as the mailbox rule. So as soon as you put that acceptance in the mail, or as soon as you click send on the email, that acceptance is valid and the offeror is locked in to the contract, unless the offeror has specified some other means, some other terms for the acceptance. So the mailbox rule is a default rule, but the offeror, we say the offeror is the master of the contract. So if the offeror has specified something different, that the acceptance is only valid upon receipt, let's say, that would prevail. But if nothing else is specified, the default rule is going to be valid upon dispatch. As soon as the acceptance is in the mail, it's valid. Okay, so once we have that acceptance, that mirror image acceptance, we have a contract. We have offer and acceptance, and we're good. We could move on to the next stage of our analysis in that case. But let's look at the other things that might happen along the way. Now, what if there was an acceptance according to the mirror image rule, but the parties understood the terms of the contract differently? That's going to present some problems. What happens in that case? Well, we might still end up with a contract if the court is able to say that there's a more culpable party and a less culpable party. And in other words, culpable here meaning blameworthy. Is one party more blameworthy than the other for the misunderstanding? Maybe one party has an interpretation of the contract, of the terms of the contract, that's just very unreasonable. Well, they would be more culpable, the other party would be less culpable. Maybe one party is aware that there's a misunderstanding, but the other party is not aware. And the party that's aware of the misunderstanding doesn't say anything because they're hoping that later they can convince a court that their interpretation should prevail and they'll get what they want. Well, they would be more culpable. The other party would be less culpable. So the court will favor the interpretation of the less culpable party and enforce a contract on those terms. But it's possible that both parties are equally culpable. Maybe their interpretations of the terms are equally reasonable, and they were both unaware of this misunderstanding, which would just mean the terms of the contract were insufficiently clear, and in that case, we wouldn't have a contract. No contract at that point. Okay, so what else can happen besides acceptance? Well, what if the offeree purports to give an acceptance, but this is an acceptance with new or different terms from the original offer? Now, again, we're talking common law now, not UCC. This is going to count as a counteroffer. This is a counteroffer, right? Which is going to terminate the initial power of acceptance and move it back to the other party. So for now, if that happens, there is no contract. However, there's another possibility here. If the offeree purports to accept, but their statement of acceptance contains new terms, well, they might make those new terms explicitly independent or collateral of the original terms. So if I'm the offeror and I say, I'll give you $20 to rake my leaves, and the offeree says, yes, I accept, I will rake your leaves for $20. Also, separately from that, additional to that, I'd like to clean your gutters for $50. Okay, well, what we have there is we have a contract for the raking of the leaves and a new offer for the cleaning of the gutters, because that offer for the cleaning of the gutters, those were new terms explicitly independent of the initial offer, collateral terms. In that case, we have a contract consisting of the original offer and acceptance, and then we also have a new offer because those terms were made explicitly independent, explicitly collateral. Okay, what else might happen? If there's a bilateral contract offer, the offeree might be silent. What happens then? Well, typically, silence is not acceptance. Usually, silence means there's no contract. But as is often the case in law, there are some exceptions. What are the exceptions? Well, there's an exception if the offeror would reasonably expect to be notified of the rejection because prior dealings suggest that there would be a contract. So if the two parties have been dealing with each other continually on a recurring basis, such that the offeror would expect to be notified if their offer was rejected and they don't receive a rejection, that could mean that there's still a contract. And that's going to be very fact specific. We'd have to look at the facts of the case. But for now, you should just know sometimes when there's silence, there can still be a contract based on the prior dealings between the parties. There can still be a contract. The other situation in which silence could still create a contract is if the offeree derives benefits from the work of from the offeror with knowledge that the benefits have been offered for compensation, ample opportunity to reject, and knowledge of the offeror. So let's think about what this means. So let's say I'm at home, somebody knocks on my door, kid knocks on the door and says, I will, well, let's make them not a kid, let's make them 18 years old for the purposes of legality here. They knock on the door and say, hey, I'd like to rake your leaves for $20. And before I have a chance to say anything, let's say my phone rings and I get on the phone and I say, hold on for just a second. And while I'm talking on the phone, they start raking my leaves. And I see them raking, I'm talking on the phone. And maybe I just engage in a long phone conversation while I'm standing on my porch. And while this is happening, they rake my entire yard. It's a long conversation. Well, in that case, I've derived benefits from that work, knowing that the work was offered for compensation, right? They said they do it for $20. I had the opportunity to reject it, right? I'm standing there. I could say, hey, stop it. I don't want to pay you. I have knowledge that this is going on. I didn't go somewhere else and not see the raking take place. It took place with my knowledge. So we check all three of these boxes. So in that case, there's a contract, even though I didn't explicitly say, yes, I agree, but I did derive benefits with the knowledge that the benefits were offered for compensation. I had the opportunity to say no, and I had knowledge that this benefit was being conferred. So in that case, we have acceptance through silence. Okay, so we still have a contract in that case. What about partial performance? What happens if the offeror makes an offer, the offeree starts to perform? Well, partial performance, if we're dealing with a bilateral contract, is going to be an implicit promise to finish. So we do have a contract. If I say to someone, will you rake my leaves for $20? And they start raking, well, now they're bound to a contract because by starting to perform, they're implicitly promising to finish the performance. So these are the ways we can get to a contract through a bilateral contract offer. But remember, this is not the only kind of contract offer. We also have a unilateral contract offer. So let's talk about that. Now, a unilateral contract offer is accepted through performance rather than through a return promise. Usually a unilateral contract offer is going to take place if it's an offer for somebody to receive compensation to do something that the offeror is not sure that they can do, or if they're making an offer to the general public. So a good example of this is if someone hangs up a sign that says lost dog, reward $100, that's a unilateral contract offer. Think about why. Can you accept that through a return promise? If you see someone hanging that sign, can you just walk up to them and say, yes, I accept your offer to find your dog. Let me have the $100. No, you have to actually find the dog. This can only be accepted through performance. It checks both of these boxes here. It's an offer to the general public. The person hanging the sign is uncertain that this can be done. It's not a guarantee. So this is going to be a unilateral contract offer. It can only be accepted through performance. So let's talk about the rules here. So the recipient of the unilateral contract offer, the offeree, has the power to accept this offer by performance. Now, a difference between this and a bilateral contract offer is here, a counteroffer does not negate the power to accept the original offer, right? So if you see someone hanging that sign that says, lost dog, reward $100, and you say, well, I'd like to start looking for your dog, but I'll only give you the dog for $200. That would be kind of, well, say you said that, you're making a counteroffer, but in this case, it's not going to negate your power to accept that $100 if you find the dog. The person hanging the sign could accept or reject the $200, but you're not, by virtue of making the counteroffer, going to lose your power to accept the $100 should you find the dog. Different from how counteroffers work when we're dealing with bilateral contract offers. Okay, now what about partial performance? Partial performance, and let's switch from the dog. Let's say I've offered somebody, I have a very dirty house, let's say, and I need my house to be entirely clean by tomorrow because I'm having a party. So I call a cleaner and I say, if and only if you can make my house spotless, big job, by tomorrow, I will pay you $500 or something. Now, I don't know that they can do it, right? That's one of the criteria here. This is how we know it's a unilateral offer. I'm uncertain if they can do it, but if you can do it, I'll give you $500. Well, let's say they begin performing, partial performance. Well, that creates what's called an option contract. What is an option contract? That means the offeror is bound by the offer, but the offeree is not. So once they start cleaning, I can't then say, you know what, I've changed my mind. I don't want to extend this offer to you anymore. You know, go home. I can't do that. Once they start performing, once they start trying to meet that deadline of cleaning my house by the deadline I've provided, I'm bound. I need to give them a reasonable time, in this case up to the deadline, to complete the performance. However, the offeree is not bound. The offeree is not bound. The offeree could walk away. That's how an option contract works. The offeror is bound. The offeree has a reasonable time to complete the performance and is not bound. They can walk away, but the person who made the offer cannot walk away. Option contract, that's what happens if there's a unilateral contract offer and the offeree begins partial performance. They begin trying to do the thing that it is not certain that they will be able to complete. Okay, but there's a difference between partial performance and mere preparation. And then sometimes it's fuzzy where we draw this line, but if we stick to the previous example, let's say that person simply put some cleaning supplies in their car and started driving to my house. Well, at that point, am I bound? No. That's going to be mere preparation. That's not going to be partial performance yet. Probably partial performance doesn't begin until the cleaning actually starts. So mere preparation does not begin an option contract. Partial performance does. So that is everything about offer and acceptance. Not everything that there is in the world to know about this topic, but everything on my flowchart, and probably enough to help you not fail this topic in your contracts course if you're in law school. So that's what I have for you. Thank you very much for watching. If this video was helpful to you, I hope you will consider making a donation. You could go to patreon.com/BensLaw. You could send me some money on Venmo or Cashapp. I'll put the links below in the description. And I thank you very much for watching. I really do hope that this was a helpful video for you. And I want to thank my supporter on Patreon, Kate Lyon. Thanks very much. I appreciate you. And I will see everybody next time. Thanks.